So the key distinction is that if a person makes a power of attorney, they are the one choosing who, as the attorneys, looks after their affairs for them. If a person doesn't have capacity or has lost capacity and doesn't have a power of attorney in place, it's at that point then that the Court of Protection has to decide who is the best person or organisation potentially to look after this person's affairs. So if a person can make a power of attorney, it's always the best way forward because it gives them that freedom of choice. However, the court will always endeavour to appoint the right people or organisation for a vulnerable person who's lost capacity and will always look at ultimately the best interest of that person.
Hello, Sarah. Hello. Back again to the Carecast.
Good morning. Thank you for having me.
Now, remind me, last time, what did we talk about?
We explored all things powers of attorney last time.
No, that was really enlightening, actually. And today, you come to talk about courts of protection and your role in that and the service you offer and what it all means. And these conversations are really good for people that don't know anything about this, like myself, or I know a limited amount. But what we're trying to obviously get out of this is anyone that listens to this is going to really find out about that subject and enlighten themselves. But so to anyone who hasn't heard of what the Court of Protection is, what is the Court of Protection and what's its function?
Well, it's a little bit of what it says on the tin. The court is a branch of the wider courts of England and Wales, and the whole remit of the court is to protect the vulnerable in our society. So where we talked about powers of attorney previously, which is something that someone appoints someone else, loved ones, etc., to look after their affairs for them, the Court of Protection gets involved where a person lacks capacity or might lack it and need an independent intervention. So if they haven't got a power of attorney in place and decisions need to be made for them, the chances are the court needs to be involved.
Sometimes people perceive that arranging a power of attorney is a lot of hassle, but obviously if you don't have a power of attorney and you have to go to the Court of Protection, that's the more involved operation, really, isn't it?
Yeah, so the key distinction is that if a person makes a power of attorney, they are the one choosing who, as the attorneys, looks after their affairs for them. If a person doesn't have capacity or has lost capacity and doesn't have a power of attorney in place, it's at that point then that the Court of Protection has to decide who is the best person or organisation potentially to look after this person's affairs. So if a person can make a power of attorney, it's always the best way forward because it gives them that freedom of choice. However, the court will always endeavour to appoint the right people or organisation for a vulnerable person who's lost capacity and will always look at ultimately the best interest of that person.
Gotcha. And the court's best interests are all about the best interest of the person who has lost capacity. Can you explain what best interest means in principle, please?
So it's underpinned and central to the Mental Capacity Act 2005. So best interests is making decisions for somebody who can't make them themselves to try and achieve the best outcome for them. So it would be in terms of ensuring that their care package is optimised, where they live is safe and suitable, who they spend their time with, taking into account their wishes and feelings. If you've got a vulnerable person who has a particular religion or cultural interests or beliefs or values, all of those things shape who we are as individuals. So making decisions for someone else, we have to think about their best interest. That's what the court does when they are looking at applications. And it's what the people who look after a vulnerable person, whether it's an attorney under an LPA, a deputy appointed by the court, or any professional, a lawyer like me or a care provider like your good selves, we all have to have that individual's best interest in mind. What do they need? What would they like? And how best can we achieve it?
Most people know that they should have a will, but maybe not a lasting power of attorney. What's the critical difference, Sarah, between lasting power of attorney and having to go to the court of protection for a deputyship?
So the central difference is who decides, who makes the decisions. So attorneys and deputies have very similar roles. They look after the affairs of somebody else. The key difference is that someone making a lasting power of attorney would decide who they appoint to look after their affairs. They would decide how those decisions are made and when. In contrast to that, a deputyship granted by the Court of Protection is where the court will decide. So an application would be made on behalf of someone. So let's say it was me. I've lost mental capacity. My parents, my other half, might apply to the Court of Protection for a deputy order. That isn't necessary in my circumstances because I've made an LPA already while I've had mental capacity. So the key difference then is a lasting power of attorney. An LPA is a voluntary legal document that anyone who has the mental capacity and the desire to make one can do, and they get to choose. And a deputyship is where the Court of Protection appoints a deputy or deputies, if there's more than one, to make those decisions in the absence of an LPA or another power of attorney and in the absence of mental capacity.
Gotcha. What happens if the will of someone who's lost mental capacity needs to be changed? And discuss, if you would, the sort of scenarios when a will might need to be changed. And does the Court of Protection get involved in that?
First of all, a will can only be made by an individual that wants to make it, at least in the first instance. So I have a will in place. No one else can change it for me, even though I've made an LPA and even if I had a deputyship. If that will needed to be changed, it wasn't suitable anymore, the most common reason is it includes a beneficiary that shouldn't be a beneficiary anymore. The most typical one I come across.
If the beneficiary's passed away, or what?
Possibly if they passed away, but more likely is if there's been a breakdown of the relationship or that they are no longer appropriate to receive the funds for possibly another nefarious reason.
Yep.
So in that instance, then, if somebody has lost mental capacity, they can't make a new will themselves or update their current one if they've got one. And if the intestacy rules are not appropriate, so if somebody has lost capacity and they don't have a will, the law decides what happens to their assets or their estate when they die. And if the outcome of that is not in the person's best interest, and again, there's no mental capacity to solve it with a will, at that point then, an application can be made to the Court of Protection for what's called a statutory will. So that is a will that is prepared on behalf of someone who's lost mental capacity and is sealed and endorsed as valid by the court. So to be clear, someone else can't make a will for someone else. We've either got to make it ourselves, or one has got to be sent to the court with a request that it is validated.
Lovely. Brilliant. Sarah, are there any big decisions like selling their home or perhaps giving a large sum of money to a grandchild that a financial deputy still has to go to the Court of Protection and ask their permission on?
Yes. So the deputy order, so the court order that appoints the deputy for somebody who's lost capacity, will contain the authority that the court has granted at the outset. In terms of gifting, or even just a big financial decision, like you say, perhaps selling a home, the starting point is the deputy order. What does it say and what does it prohibit? If an order is silent, as a general rule of thumb, it would indicate that the court's authority is needed to do something. But anyone watching this as a deputy or a potential deputy, do get advice before applying, just in case it's not necessary. But gifting is very restricted under the law, which is naturally to protect the vulnerable individual. And so are important decisions such as selling property or purchasing another one, letting one out, etc. So typically, court authority is needed for such things. And it's always a good idea to seek advice, even if you ultimately apply to the Court of Protection yourself rather than with a lawyer. I'd always recommend seeing a specialist Court of Protection lawyer or mental capacity lawyer to make sure that your application captures everything you need it to. Because many times in my practice, I've had clients or families come to me and say, we've made this application, it's been refused. Is there any point applying again? And as soon as I've read through it, I say, yes, there is, and here's what we can do. So it's always worth getting advice before you go to the court to make sure that you optimize the whole process for yourself and for the loved one at the middle of it.
Absolutely. Sarah, for many families, arranging living care is a significant financial commitment, or it could be choosing a care home or whatever decisions that they have to make for the loved one. How does the court ensure that a deputy is spending the person's money wisely and only on services that really are in that person's best interest or that are necessary, I suppose?
So the Court of Protection primarily deals with the legal appointment of deputies and also actions and authority by attorneys under an LPA. In terms of supervision, that falls to the Office of the Public Guardian, the OPG, which is a government body that's connected but separate from the court. And the job of the OPG and the Public Guardian, who sits at the top, if you like, is to supervise and oversee deputies and attorneys. So that is to ensure that they're acting within the authority that they've got under their documents, so the deputy order in this case, and the law. And it also helps to ensure, just like you described, the payments being made in and out are appropriate. And they do that via an annual report. So every financial deputy will complete a report every year for the deputyship year. So if you were appointed as a deputy for someone on the 1st of June, you would fill a report every year from the 1st of June up to the 31st of May every year. And that goes to the OPG. They will review it and they will make sure that money in and money out, and also other things like decisions that have been made within that year, whether they're purely financial or not, they'll be recorded too. So the OPG has a full picture of that vulnerable person and what the deputies have done in that year. If the OPG has a query, they'll always go back to the deputy and just ask for clarification, just to make sure that it's not a misunderstanding or something's a bit unclear. And if there are any major concerns, they will either advise the deputy to go to the court for a certain, usually it's for authority for something, or they may go to the court directly and say, we think there's an issue here, and ask the court to intervene. So that's how deputies are overseen in terms of making decisions and spending money on behalf of someone else.
Sure. Have you got any idea how many deputies are found to maybe act improperly or fraudulently every year? If any, I'd love to know that stat.
So the statistics for that would be very unreliable, I would say, or very subjective, because you have a whole host of reasons why a deputy might be investigated, for example, or even queried. The vast majority of the deputies that I work with who are applying for permission or retrospective permission, so the OPG have said, we're not happy with this, you need to apply to the court and have it sealed, essentially, for approval. Usually it's very genuine. It's a gap in understanding of the law or the authority of the deputyship. So even if you had a statistic that said this many cases were referred by the OPG to the court, it doesn't necessarily mean that there's any shady goings on.
What the family's concern that someone who already has a registered lasting power of attorney is abusing their position or simply not doing a good job? What steps can they take? What remedies are there for them?
So again, the OPG is a very good starting point. It's the OPG's role to oversee attorneys and deputies. So if there is a safeguarding concern, whether that is a welfare concern, a financial abuse one, or both, the concerned parties should go to the OPG and record it and report it with them. And they have powers to investigate and refer to the court. They could also, this is outside of the court and the OPG as such, but what they could do is also report concerns to adult social care or children and young persons care in the local authority. They should keep good records themselves in case they ever need to evidence their concerns to the various bodies that we're talking about. And it's worth considering making a non-urgent or urgent report to the police as well if there's genuine concerns of financial abuse or coercive control, anything that comes under the criminal sphere. It's worth considering. So the best thing, if somebody is watching this and concerned about what an attorney or a deputy or a family member is getting up to, OPG, consider the local authority and consider whether the police would be appropriate to notify as well.
There is a lot of information out there about court protection and LPAs and wills and whatnot. What are some of the biggest myths that exist around this subject matter?
Oh gosh, there's lots of ones I could think of. In terms of sticking with the court of protection theme, there's a little bit of a myth surrounding personal welfare deputyship in particular. So very often families come to me and say, we need to apply for a personal welfare deputyship. We've been told by, for example, a social worker or a medical professional that we need it, we should have it. They can't do anything, or we aren't allowed to make decisions without it. That is, as a starting point, just not true. The law isn't that without a personal welfare deputyship, you can't make personal welfare decisions for someone. It comes back to best interests again and what is in a person's best interests. And a key consideration for the court under the law is whether a deputyship is the least restrictive option for that person having decisions made for them. And if there's another way, if decisions can be achieved another way, then the court is actually quite reluctant to make a personal welfare deputyship. So that's one where I always encourage anybody who's thinking about those particular decisions and who's got that advice, again, see a qualified specialist lawyer before making an application to save yourself and the court the time and the stress and the cost of making an application. So that would be a big one. I can give you some others if you like.
I was thinking actually for families or friends of someone who may be vulnerable at the moment, obviously hasn't yet lost a capacity, and they're watching us and thinking and worried about it. What's the most critical piece of advice you could give that person about protecting their loved one's future?
So if there isn't a power of attorney in place for somebody and the circumstances are that it would be a good idea, it's absolutely critical not to disregard their ability and capacity to make a power of attorney. It's always worth exploring because they don't have to understand every piece of legal jargon or exactly the mechanics of how everything would work. The key is that they need to understand a power of attorney sufficiently. And we haven't got time here today for me to really break it down. But capacity is also decision specific. So someone may well be able to make a power of attorney, even if they now can't manage their own money. They might not know who the Prime Minister is, but it doesn't mean they can't make an LPA. The other thing is the conditions. So I'm going to meet a lady in 2 weeks. In fact, I've got a new client and I'm going to see her at nighttime because of various complex needs that she has. She is much, much better and functional in the evening and at nighttime. So I said, I'll block some time out of my diary and off I go because that is the right thing for her. So going back to your question then, for families and anybody watching this who thinks that we need to get this sorted, don't dismiss an LPA just because somebody has problems with their memory or is starting to show signs of struggling with their affairs. And then if a power of attorney isn't an option, then consider whether a deputyship or a court application for something specific is actually required. Because again, sometimes people apply when they don't need to. Yep. And other times people don't apply when they really do. So getting advice is so important to give you the peace of mind and your loved one at the center of all this, the vulnerable person, to make sure that everybody is protected and covered under the law.
It's been really enjoyable speaking to you again, Sarah, and learn a hell of a lot there as well. And to all our listeners, thanks for watching and listening. If you did find the video helpful, please give it a thumbs up and subscribe to our channel for more insights in and around the care world. Thanks so much for your time, Sarah. Good luck with your exam next week.
Thank you very much. And my pleasure. Thank you for having me. And thank you for watching, everyone.
Thank you.